Welcome, everyone, to the deep dive. Today, we're really digging into some pretty significant shifts, changes that could directly impact your finances and, your immigration journey here in the U.S.
That's right.
We've spent time going through the latest policies, gathered some crucial insights. We're talking about a new U.S. tax on money transfers overseas, and also some really critical updates to green card applications and renewals.
Exactly. And our goal here, our mission for this deep dive, is really to help you cut through all that complexity. These announcements can be confusing. So we'll break down what they actually mean for you, highlight what's essential to remember, and hopefully give you those aha moments. Make staying informed feel a bit less overwhelming.
Yeah, making it practical.
It's about practical knowledge you can actually use.
Absolutely. So let's peel back the layers, shall we? On these two major areas, we'll unpack what you need to know. Let's start with a topic that's been causing, well, quite a bit of chatter lately,
Right.
this new U.S. tax on remittances. We've certainly heard a lot of discussion, maybe some confusion, about a new tax on sending money out of the U.S. Can you give us the overview? What exactly is this remittance tax, and why now?
Yeah, absolutely. What's kind of interesting here is that for years, for a long time, money sent from the U.S. to other countries' remittances, it largely went untaxed by the federal government.
Right, that was the status quo.
But that's changed. A remittance tax is basically a federal excise tax. It's applied directly to money sent abroad from the U.S. And this new legislation, part of what was controversially nicknamed the One Big Beautiful Bill.
Heard that phrase.
Yeah, it brought this tax into effect. It's a big piece of legislation, lots of things in it. And this tax on outward remittances is one part. It officially goes into effect January 1st, 2026.
Okay, January 2026. Now, I seem to recall hearing about some much higher proposed rates initially. That caused quite a stir, didn't it? What's the final percentage that actually passed, and who exactly does this affect?
You're right, there was a lot of back and forth on the rate. It started, the proposal was 5%, then it got reduced to 3.5% during negotiations.
Okay.
And ultimately, it passed at 1% in the final reconciled bill.
1%.
1%. And it applies broadly. We're talking all individuals,
Yeah.
U.S. citizens, green card holders, non-citizens to anyone sending money abroad from a U.S. account. And crucially, the sender always pays the tax.
Ah, the sender, not the person receiving it overseas.
Correct. It's collected by the service provider, the bank or the money transfer service handling the transaction.
Right. 1% is definitely lower than 5%, but still, it's a new cost for many people. Now, here's where it gets really interesting, I think, for our listeners. Does this mean all types of money transfers are now taxed at 1%? Or are there specific methods this applies to? This seems like a key distinction.
This is absolutely crucial, and it's where a lot of the misunderstanding comes from. The 1% remittance tax applies only, and this is the key part, only when the sender provides cash, a money order, a cashier's check, or a similar physical instrument to the remittance provider.
This is like actual paper.
Exactly. The insight here seems to be that this tax targets those less easily traceable forms of money transfer. It's almost like a nudge towards more transparent digital channels.
Right, which are easier to track.
Correct. So it does not apply to your standard electronic fund transfers like ACH, automated clearinghouse transfers, those common bank-to-bank electronic payments.
Okay.
It also doesn't apply to wire transfers or those app-based remittances you send directly from your U.S. bank account, or even transfers funded with a U.S. debit or credit card.
So if I use my bank app or Zelle or something like that, no tax.
Generally, no. Based on the rule targeting physical instruments, also inward remittances, money coming into the U.S., those are not taxed either. Your bank or service provider, they'll automatically collect this 1% tax, but only on those physical transfers.
Okay, that clarifies a lot. It's really about the method, physical paper versus digital. Now, beyond that direct financial cost, what about the broader implications? We've seen some pretty strong concerns raised by various groups, haven't we?
Oh, absolutely. If you look at the bigger picture, many immigrant advocates have argued quite strongly that this 1% tax, it's like a form of double taxation.
How so?
Well, think about it. Senders have already paid income tax on the money they earned, right? The money they're now sending abroad.
True.
And now they face this additional federal excise tax just for the act of transferring those funds. So the argument is it disproportionately hits immigrant communities who often send money home.
I see the point.
And the financial industry isn't exactly thrilled either. Groups like the Financial Technology Association, they remain skeptical, even at just 1%. They argue it could hurt everyday Americans, burden common financial activities, maybe even stifle innovation in the digital remittance space.
It really sounds like this could impact families relying on these funds for basic support. We heard that example, Ajay, the engineer sending money to his mother in Mumbai. How does this fit into the larger global picture, especially for countries that receive a lot of these remittances?
Yeah, Ajay's situation is a perfect example of the real-world impact. Take India, for instance. It's the world's top recipient of remittances. We're talking $118.7 billion in 2023-24 alone.
Wow, that's huge.
It is. It's about 3% of India's GDP. And these funds, they aren't just, pocket money. They're often crucial for daily expenses, sure, but also for savings, buying homes, investing in small businesses, paying for healthcare, education.
Essential.
Exactly. So a drop in remittances, even from a seemingly small 1% tax, it could lead to lower household savings, less investment in these local economies. Some analysts worry it could be like a double blow for poorer regions, especially if it combines with cuts in global aid. It's a ripple effect.
That makes sense, which raises an important, maybe slightly concerning question. If these official, now taxed channels become more costly or just feel more scrutinized, what happens then? Could people turn to, well, other ways to send money? Less formal ways?
Unfortunately, yes, that's a real concern. To avoid the tax and maybe the increased scrutiny that comes with it, some individuals might feel pushed towards informal channels, or even illegal ones like Hawala.
Hawala, right. That's based more on trust networks.
Exactly. It operates completely outside the formal banking system, often based on deep community trust. But it comes with significant risks. U.S. law considers Hawala illegal, primarily because it bypasses regulations designed to combat money laundering and terrorist financing.
So risky for the sender, too.
Very risky. There's no legal recourse if the money disappears or if there's fraud. And you could be exploited by criminal networks. Plus, there's an impact here, potentially. If people cut back on their spending here in the U.S. on goods, services to make sure their families abroad get the full amount intended, that could actually slow down economic activity domestically, too.
Lots of interconnected effects there. Okay, so we've navigated the new landscape for sending money overseas. Now let's pivot. Let's talk about equally crucial updates affecting the immigration journey here in the U.S., specifically those vital green card processes. Let's talk about the medical exam, Form I-693. What's new there? Big changes.
Yes, this is quite fascinating, actually. There's a recent policy update from USCIS, effective June 11th, 2025, and it marks a pretty significant shift in how they handle medical exam results.
Okay, what's the shift?
Well, you might remember some earlier guidance suggesting that Forms I-693 signed after November 1st, 2023 might be valid indefinitely. But this new policy clarifies things. An I-693 is now generally considered valid only for the specific immigration benefit application it was submitted with.
Only for that one application.
Pretty much. The aha moment here is USCIS seems to be moving towards a one application, one medical exam policy. So even if your health is exactly the same, the sort of bureaucratic reality is that if your application is denied or withdrawn.
Even for non-medical reasons?
Yes, even if the denial has nothing to do with the medical exam itself. If that application ends, that medical exam form becomes invalid. You'll need to get a brand new Form I-693, go through the whole process again for any future application.
Wow, okay, that sounds like a significant change. So, just to be clear, my green card application gets denied, maybe because of a paperwork issue, but my medical exam was perfectly fine done recently. I still have to get a completely new medical exam if I reapply later.
That's the gist of the new policy, yes.
Yeah.
It seems like it could be a considerable burden for applicants, both time and money-wise.
Yeah, definitely adds cost and hassle. What's the reasoning from USCIS?
USCIS states the aim is to safeguard public health. They want to ensure the medical results are timely, current, and that applicants actually follow up on any necessary treatment identified during the exam.
Okay.
Previously, there was a potential risk, they argue, of outdated results being used. So this new rule links the exam's validity tightly to the specific application it supports. It's presented as a balance between public health and, well, applicant convenience.
Right. Can you remind us what the medical exam actually involves? What are the doctors looking for, and what's the typical cost?
Sure. The main purpose of the exam is to prove you aren't inadmissible to the U.S. on public health grounds. It has to be done by a USCIS-authorized civil surgeon. These are specific doctors designated by USCIS.
Not just any doctor.
Correct. They check for what are called Class A medical conditions. These are serious health issues that could make someone inadmissible. Things like certain communicable diseases, active TB, gonorrhea, syphilis. They also check that you have all the required vaccinations.
Vaccinations too, okay.
Yep. And beyond diseases, the surgeon looks for any physical or mental disorders that might pose a risk of harmful behavior to yourself or others. And they screen for drug addiction. As for cost, there's no fee for filing the Form I-693 itself, but the exam fee charged by the civil surgeon typically ranges from, say, $100 up to $500.
Quite a range.
Yeah, the average is probably around $200. And remember, as of December 2, 2024, USCIS generally requires you to submit this completed I-693 with your main green card application, the Form I-485.
Submit it up front.
Yes, the idea is to make processing more efficient and cut down on those requests for evidence, RFEs, which happen when USCIS needs more info because something was missing initially.
Got it. Streamlining. Okay, so that's the initial application. But renewing or replacing a green card, that's something many people do, right? Usually every 10 years. We've also seen recent updates to Form I-90, the application to replace permanent resident card. What should folks know there?
Yes, absolutely. And the key here is always use the latest form. USCIS issued a new edition of Form I-90 dated January 20, 2025. And starting May 29, 2025, that became the only edition they accept.
Only the new one after that date.
Correct. USCIS updates forms pretty regularly, maybe to clarify instructions, collect data better, adapt to new laws or policies. So it's just a strong reminder. Whenever you're submitting any immigration form, job one is to go to the USCIS website and make sure you have the absolute most current edition. Using an outdated form, that's such a common but easily avoidable reason for rejection or delays.
That leads perfectly into my next question. Given all these specific forms, policy details, deadlines, what are some of the most common mistakes people make? The things that lead to a green card application or renewal getting denied. And maybe more importantly, how can our listeners avoid them? This feels like where practical advice is really needed.
It's a really important question. How do you navigate this smoothly and avoid those dreaded denials? Based on what we see helping people, many denials actually stem from what seem like small errors, but they add up.
Little things matter.
They really do. So here are the top pitfalls you absolutely need to be aware of and how to steer clear. First, incorrect or incomplete information. It sounds basic, right?
You'd think so.
But it's amazing how often it happens. Even just leaving a field blank when it should say none or NA, or a misspelling, an inaccurate date. Any inconsistency can flag your application for denial. You have to double check, triple check every single detail, make sure it matches your official documents exactly. And provide all the required supporting documents like recent passport photos that meet the very specific size and background rules, or current proof of address. These details matter immensely to USCIS. Okay, meticulous checking. What's next? Second big one, submitting the wrong application form. This is a really frequent and costly slip-up.
Oh boy. Example.
Okay, say you're a conditional resident. That means your green card is only valid for 2 years, usually because you got it through a recent marriage, or as an EB-5 investor.
Right, the 2-year card.
You have specific forms to remove those conditions. If it's marriage-based, you need Form I-759. If you're an EB-5 investor, that's the employment-based fifth preference visa, you need Form I-829. Now, if you mistakenly file Form I-90, which is just for renewing a regular 10-year green card that's expiring, instead of the correct I-751 or I-829, that's a huge problem. It can cause massive delays. Worse, it could actually lead to USCIS terminating your conditional status.
Which could mean deportation proceedings.
It could, yes. Using the wrong form is a serious error.
Yikes. Okay, what else?
Third, criminal history. This is obviously a major concern. Certain criminal offenses, especially things classified as aggravated felonies or sometimes multiple misdemeanors involving moral turpitude, can make you inadmissible and result in denial.
Even for a renewal.
Even for renewal. USCIS runs thorough background checks every time. So if you have any kind of criminal record, even something that seems minor or happened a long time ago, you absolutely must seek expert legal guidance before you apply. Don't just hope they won't find it or it won't matter.
Get advice first.
Yes. An immigration attorney can assess your specific record, see if you're still eligible, maybe if there are waivers available. It's compulsory, really.
Makes sense. Number 4.
Fourth, failing to attend your biometrics appointment. This is mandatory. USCIS needs your fingerprints, photo, signature, your biometrics for background and security checks.
Right, the fingerprinting appointment.
Exactly. If you just don't show up and you don't reschedule beforehand, they can deny your application automatically. If you genuinely cannot make the scheduled date, you must follow the instructions on the notice to request rescheduling before the appointment date passes. Don't just be a no-show. Communicate.
Okay. Crucial step. What's 5th?
Fifth, Traveling abroad for extended periods. This trips people up sometimes. If you're a green card holder, you're expected to reside permanently in the U.S. If you spend more than 6 months outside the country on a single trip, USCIS might decide you've abandoned your residency when you apply for renewal.
6 months is the key time frame.
Generally, yes, stays over 6 months, raise flags, stays over a year are even more problematic. If you know you need to be outside the U.S. for an extended period, but you intend to return, you should apply for a re-entry permit before you leave.
For re-entry permit.
Yes, Form I-131. This document shows USCIS your intent to return and can protect your permanent resident status for up to 2 years while you're abroad. If you end up staying out even longer, maybe over a year, due to circumstances truly beyond your control like a serious medical issue, you might need to apply for an SB1 returning resident visa at a U.S. consulate abroad to come back, which involves proving you never intended to give up your U.S. residency.
Complex. Okay, number 6.
Sixth, applying too early or too late. Timing is critical. For the standard Form I-90 renewal, you should apply within the 6-month window before your 10-year card expires, not earlier.
Within 6 months before.
Yeah. Yes. For removing conditions, Form I-751 for marriage. It's typically within the 90 days before your 2-year conditional card expires. There are some exceptions if you're filing late due to divorce or abuse, but generally that 90-day window is key. For the EB-5 investor, Form I-829, it's also usually within 90 days before the conditional card expires. Applying too early gets it rejected. Applying too late? Well, that can seriously jeopardize your status, cause huge delays, maybe denial, and in the worst case, put you into removal proceedings.
So pay close attention to those dates. Okay, is there a final pitfall?
Yes, the last one, and the most serious. A court has decreed your deportation. If an immigration judge has already issued a final order of removal against you, applying for renewal is obviously not straightforward. Immediate legal action is vital.
What kind of action?
You need to explore options like filing an appeal if the deadline hasn't passed, or maybe a motion to reopen or reconsider your case based on new evidence or legal arguments. Time is absolutely critical here. You need expert legal counsel immediately to see if the order can be challenged or if any other relief might be possible.
Definitely a situation for immediate legal help.
Okay, that is an incredibly helpful, practical breakdown of things to watch out for. We've really covered a lot today, haven't we? From the details of that new 1% remittance tax on physical transfers to these critical updates on green card medical exams and these very common but hopefully now avoidable pitfalls in the application and renewal process.
Indeed. And I think for all green card applicants listening, whether you're applying for the very first time or going through a renewal, the absolute key takeaway is vigilance. Meticulous accuracy.
Attention to detail.
Exactly. Be incredibly precise with every piece of information. Double check everything. Ensure you're using the correct form and always the most current version from the USCIS website. And stick strictly to those deadlines. Pay very close attention to the new rules for Form I-693, the medical exam. Remember, its validity is now tied directly to that specific application, generally 1 exam per application attempt.
And, as we discussed, if your situation has any complexities, maybe a past criminal issue, however minor, or plans for extended travel outside the U.S., getting expert legal guidance isn't just, helpful, it's really compulsory. Understanding these rules, preparing diligently, that's what prevents significant delays, extra costs, and potentially even a heartbreaking denial.
Sound advice. Preparation and vigilance are key. Well, thank you for breaking all that down for us.
My pleasure.
All the best to everyone navigating these processes, and we will meet again with another important tax matter again.